6 months earlier, I drove down Maple Creek Lane with the realtor, my heart pounding with excitement as we approached the house that would soon become my home. After years of saving, countless overtime shifts and sacrificing vacations, I was finally about to achieve the American dream of homeownership. The neighborhood looked like something from a magazine: perfectly trimmed lawns, welcoming front porches, and children riding bicycles along the sidewalks. This community is extremely well maintained, my realtor explained as we pulled into the driveway of a modest two-bedroom house with blue shutters and a small front garden. They have an active homeowners association that ensures property values remain high. I nodded appreciatively, admiring how clean and orderly everything looked. The association fees seemed reasonable for the amenities provided: a community pool, playground, and regular landscaping of common areas. I signed the papers the following week, and by the end of the month, I was unpacking boxes in my very first home. The neighbors welcomed me warmly. On my first weekend, Robert and Sarah from across the street brought over a homemade casserole. The Patels next door invited me for coffee and offered to help with any home repairs I might need. For the first time in my adult life, I felt a sense of belonging to a community. "You must be our new neighbor," an elderly man named Frank called out one morning as I collected my mail. He walked over, leaning slightly on a wooden cane. "Welcome to Maple Creek. You will love it here, but just a word of advice: make sure you read the HOA guidelines carefully." His friendly smile faltered slightly. "Corinne Thompson runs the board with an iron fist. Best to stay on her good side." I thanked him for the tip but did not think much of it. Every community had its characters, and I was determined to be a model resident. I read through the thick binder of HOA regulations, noting rules about lawn maintenance, exterior paint colors, and holiday decoration guidelines. Some seemed overly specific, but I understood the desire to maintain the neighborhood's charm. My first encounter with the infamous Corinne Thompson came 3 weeks after moving in. I attended the monthly HOA meeting held in the community center, hoping to meet more neighbors and learn about upcoming events. Corinne sat at the head of the table, her platinum blonde hair styled in an immaculate bob, her posture rigid as she called the meeting to order. "We have several violations to address," she announced, her voice sharp and precise. "The Millers at 342 have installed unapproved solar lights along their walkway. The Jacksons at 156 have failed to remove their basketball hoop despite 2 previous notices. And Ms. Chen at 287 has planted non-approved rose bushes in her front garden bed." I watched as homeowners tried to explain their situations, only to be systematically shut down by Corinne citing specific bylaw numbers without even glancing at the rulebook. Her perfectly manicured nails tapped impatiently on the table as residents spoke, her eyes cold and evaluating. The meeting felt less like a community gathering and more like a disciplinary hearing. The following morning, I discovered my first violation notice taped to my front door. "Mailbox not in compliance with Regulation 7.3, improper shade of black. Must be repainted within 7 days to approved color midnight onyx, available at Sherwin-Williams." I stared at my mailbox, confused. It was black. How many shades of black could there possibly be? Nevertheless, I purchased the specified paint and spent my Saturday afternoon repainting it. I also drafted a polite email to the HOA board explaining that, as a new resident, I would appreciate some grace period to learn all the regulations. The reply came from Corinne herself. "Rules apply equally to all residents regardless of tenure. Further violations will result in financial penalties. No welcome, no understanding, just cold enforcement. That was the moment I realized my perfect neighborhood dream had an unexpected shadow looming over it. The repainting of my mailbox was only the beginning. 2 weeks later, another violation notice appeared. Front lawn exceeds maximum grass height by 0.5 inches. Fine, $50. I measured my grass with a ruler and found it was indeed slightly over the 3-inch maximum. I mowed immediately and sent photographic evidence of compliance, requesting the fine be waived as I had corrected the issue within hours of notification. The request was denied. The following week brought another citation: unauthorized flower variety daisies in garden bed. Fine, $75. Then another: garbage bin visible from street outside of collection hours. Fine, $100. Each violation seemed more trivial than the last, yet the fines grew increasingly punitive. I began documenting everything. I photographed my property daily, kept records of all communications, and maintained a spreadsheet of violations and responses. Each morning, I found myself inspecting my property through Karen's critical eyes, searching for potential infractions before they could be cited. Rain pattered against my windows one Saturday morning when the doorbell rang. I opened the door to find Karen herself standing on my porch, clipboard in hand, her immaculate hair untouched by the drizzle thanks to a clear plastic rain bonnet. "Mr. Johnson, your window treatments are not in compliance with Section 9.2 of the HOA bylaws," she stated without greeting, pointing at my front windows where I had installed simple white blinds. "Those are basic white blinds," I responded, confusion evident in my voice. "The guidelines only specify that window coverings visible from the street must be white or off-white." Karen's lips tightened. "These appear to be snowfall white. The approved shade is classic white or eggshell. You have 5 days to replace them before a fine is issued." "How can anyone tell the difference between these virtually identical shades of white?" I asked, frustration creeping into my voice. "I can tell," Karen replied coolly, making a note on her clipboard. "And as HOA president, my assessment is what matters." She turned to leave, then paused. "By the way, your garden hose should be stored out of sight when not in active use. Consider this a verbal warning." As she walked away, I noticed my neighbor Robert watching from his driveway with a sympathetic expression. Later that evening, he and his wife Sarah invited me for dinner, where I learned I was not alone in my struggles. "Karen has been targeting certain homeowners for years," Sarah explained in a hushed voice, though we were in their dining room. "Usually new residents or anyone who questions her authority at meetings." Robert nodded grimly. "The Thompsons before you sold their house at a loss just to escape her harassment. They received violations almost daily toward the end." "Why does nobody stand up to her?" I asked. "She has 3 of her friends on the 5-member board," Sarah replied. "And fighting the HOA legally is expensive. Most people either comply or move away eventually." The conversation was interrupted by a text message from another neighbor warning that Karen had been seen photographing my property at dusk. I rushed home to find a new violation notice already on my door regarding improper placement of my garden gnome. The following week, I attended another HOA meeting, determined to address what was happening. When the floor opened for resident concerns, I raised my hand and calmly described the pattern of seemingly targeted enforcement I had experienced. "Point of order," Karen interrupted before I could finish. "Individual enforcement matters are not appropriate for open discussion. You must submit complaints in writing to the board for private review. But when I submit written concerns, they are dismissed without." Section 12.4 of meeting bylaws clearly states that the chair may close discussion on topics not properly noticed on the agenda, Karen stated firmly, cutting me off. Your time has expired, Mr. Johnson. I sat down, aware of sympathetic glances from other homeowners, but equally aware that no one was willing to speak up. Later that night, checking my mail, I found an invoice for accumulated fines totaling $475. The accompanying note stated that failure to pay within 30 days would result in a lien being placed on my property. As I stared at the growing list of alleged violations, many for infractions so minor they were virtually imperceptible, I realized I was trapped in a system designed to break residents through financial and emotional attrition. Karen was not simply enforcing rules, she was wielding them as weapons. The certified letter arrived on a Tuesday morning. I recognized the HOA letterhead immediately and felt my stomach knot as I signed for it. Inside was a formal notice of a major structural violation, alleging that my backyard shed exceeded height limitations by 8 inches. The potential fine, $2,500 plus mandatory reconstruction costs. I stood in my kitchen, reading and rereading the notice with mounting disbelief. The shed had been part of the property when I purchased it. It was specifically listed in the home inspection report, which had been submitted to and approved by the HOA before my purchase was finalized. How could it suddenly be in violation? I immediately took measurements and photographs, confirming the shed stood exactly 7 feet tall, well within the 8-foot maximum specified in the guidelines. I compiled this evidence and requested an emergency meeting with the board, which was reluctantly granted for the following evening. 5 board members sat behind a long table as I presented my documentation. Karen watched with thinly veiled disdain as I showed time-stamped photos and measurements. The previous homeowner received a variance for the shed, I explained, showing the inspection report. It was disclosed during my purchase and approved during the transfer of ownership. We have no record of such a variance, Karen replied coolly. And even if one existed, variances are reviewed annually and not automatically transferred to new owners. That information should have been in your closing documents. I attempted to show the approval paperwork, but Karen dismissed it with a wave of her hand. That signature is from a former board member who is no longer with us. Current board policy requires majority approval, which this does not have. Every reasonable compromise I suggested was systematically rejected. Reduce the height, not sufficient. Move the shed, would require landscaping approval that would likely be denied. Remove it entirely, would still need to pay the violation fee for the current infraction. As I left the meeting, board member Tom Wilson, a man who rarely spoke during proceedings, caught up to me in the parking lot. "Listen," he said quietly, looking around to ensure we were alone. "This is not about your shed. Karen has been going through old records looking for ways to target certain properties. You might want to look into who else has been pressured to sell recently." That night, I began researching previous homeowners who had sold under duress. A pattern quickly emerged: homes purchased by a development company with ties to Karen's husband's real estate business. Properties acquired at below-market rates after months of escalating HOA violations made ownership untenable. Desperate for professional advice, I scheduled consultations with 3 different attorneys specializing in real estate law. Each meeting ended with the same grim assessment. Fighting the HOA would require a retainer of at least $5,000 with legal fees potentially reaching $15,000 or more. Even with a strong case, there was no guarantee of success. As courts typically deferred to HOA authority, unless clear evidence of fraud or discrimination could be established. The system is designed to make it financially impractical for individual homeowners to fight back, one lawyer explained sympathetically. It is often cheaper to pay the fines or even sell your home than to challenge the HOA in court. I returned home to find another certified letter waiting, this one announcing that due to my ongoing noncompliance and refusal to address violations, the HOA was initiating legal proceedings. The case would be heard in civil court in 6 weeks. Failure to appear would result in a default judgment, potentially including a lien on my property and authorization for the HOA to make necessary corrections, at my expense. That night, I sat at my kitchen table surrounded by violation notices, legal threats, and mounting fines. My dream home had become a nightmare. The financial strain was beginning to affect other aspects of my life. I had canceled a planned visit to my parents, was skipping lunches at work, and lay awake most nights strategizing how to appease the seemingly insatiable demands of the HOA. I felt completely powerless against a system explicitly designed to grind down homeowners until they surrendered. Karen had the board, the bylaws, and financial resources on her side. I had what? A folder of denied appeals and a bank account that could not sustain both a mortgage and escalating fines, let alone expensive legal representation. Then something shifted inside me. Perhaps it was the cumulative weight of months of harassment, or perhaps it was the realization that I was not just fighting for myself, but for every resident who had been bullied into submission. If Karen succeeded in forcing me out, she would simply move on to her next target. I opened my laptop and began researching a different approach. If I could not afford an attorney to represent me, I would represent myself. The court date was 6 weeks away, 6 weeks to transform myself from a harassment victim into my own legal advocate. In that moment of clarity, fear gave way to determination. I would not be selling my home. I would not be paying unjust fines. I would be fighting back all the way to the courthouse. The transformation of my home began that very night. My dining room became command central, with the table soon disappearing under stacks of printed HOA bylaws, property codes, and legal research. The living room walls gradually filled with timelines, photographs, and color-coded index cards, mapping out connections between various incidents and violations. I took a week of vacation from work, not for rest but for intensive research. Every day followed the same grueling schedule. Wake at 5 a.m., study legal precedents until my eyes burned, break only for quick meals and coffee, then continue until I fell asleep with my face pressed against legal textbooks at midnight. My first breakthrough came while examining the HOA charter. According to state law, the association was required to maintain transparent financial records available to all members upon request. Despite 3 written requests over the past months, I had never received these documents. This procedural violation was my first concrete evidence of potential board misconduct. Further digging revealed more irregularities. HOA regulations required board elections every 2 years, yet Karen had served as president for nearly 6 years without a properly documented election. Violation notices required approval from at least 2 board members, but dozens of mine bore only Karen's signature. Each discovery was carefully documented and added to my growing case file. I expanded my investigation beyond my own situation, creating a spreadsheet tracking enforcement patterns throughout the neighborhood. The data revealed striking inconsistencies. Homes belonging to Karen's friends received no violations despite visible infractions, while properties near mine or owned by residents who had questioned board decisions showed exponentially higher citation rates. Armed with this information, I began cautiously reaching out to neighbors who had experienced similar harassment. Many were initially reluctant to get involved, fearing retaliation. However, when I explained my intention to represent myself in court, a few agreed to provide written statements documenting their experiences. "She had my children's treehouse demolished while we were on vacation," Mrs. Garcia shared tearfully. "It was built by their grandfather and met all height restrictions, but Karen claimed it was an unauthorized structure." Mr. Patel from next door revealed that his application to install disability access ramps for his elderly mother had been denied 3 times on aesthetic grounds, despite being protected under fair housing laws. Each story reinforced my resolve and provided additional evidence of selective enforcement. Learning legal procedure became my second job. I spent hours at the county law library studying civil court protocols, rules of evidence, and proper filing procedures. I took detailed notes on courtroom etiquette, appropriate forms of address, and objection protocols. The librarians, seeing my dedication, pointed me toward resources specifically addressing HOA disputes. "You are not the first person to fight an HOA without an attorney," one helpful librarian told me, sliding across a self-representation guide. "The key is meticulous preparation and focusing on procedural violations rather than individual grievances." This advice proved invaluable as I structured my defense and, more importantly, my countersuit. Under state law, HOA board members could be held personally liable for harassment, selective enforcement, and breach of fiduciary duty. If I could prove Karen had abused her position for personal gain or targeted me unfairly, she might be personally responsible for damages. As weeks passed, my confidence grew alongside my legal knowledge. I practiced my opening statement in front of the bathroom mirror each morning, refining my delivery until the nervous wavering in my voice was replaced with calm assertion. I rehearsed potential cross-examination questions with neighbors willing to help, preparing for every conceivable challenge to my evidence. 3 weeks before the court date, I made a pivotal discovery while reviewing property records. The development company that had purchased several homes following HOA disputes was registered to Karen's brother-in-law. This connection suggested a possible financial motivation behind the pattern of harassment, driving down property values to facilitate below-market acquisitions. If proven, this would elevate the case from simple selective enforcement to potential fraud. I compiled all my evidence into meticulously organized binders, one for my defense against the HOA claims, one for procedural violations by the board, and one for my countersuit against Karen personally. Each document was indexed, highlighted, and annotated for easy reference during court proceedings. I created simplified visual aids to help explain complex patterns of enforcement and financial relationships. The final week before the court date was devoted to practice and refinement. I enlisted Frank, the elderly neighbor who had first warned me about Karen, to serve as mock judge while I presented my case. His experience as a retired school principal made him ideally suited to point out weaknesses in my presentation and areas where my language became too emotional rather than factual. "Remember, stick to documented evidence," he advised after one rehearsal. "The moment you appear vindictive rather than victimized, you lose credibility with the judge." The night before the court date, I reviewed my materials one final time. My dining room looked like a legal war room, with empty coffee cups creating rings on case law printouts and takeout containers stacked beside property code manuals. I had transformed from a homeowner drowning in unjust violations to someone prepared to challenge the system that had created them. As I carefully packed my evidence binders into a borrowed briefcase, I felt a strange calm settle over me. Whatever happened tomorrow, I would face Corinne as an equal in the eyes of the law, not as a powerless homeowner, but as my own advocate armed with months of painstaking research and irrefutable evidence of wrongdoing. For the first time since moving to Maple Creek Lane, I slept soundly through the night. The county courthouse stood imposing against the morning sky, its stone steps already crowded with people hurrying to various proceedings. I paused at the base of the stairs, taking deep breaths to steady my nerves. My borrowed briefcase felt unusually heavy, though I knew it contained only my carefully prepared evidence binders and a legal pad for notes. Inside, I navigated the bustling hallways until I found the correct courtroom. Through the wooden doors, I caught my first glimpse of what awaited me, an austere room with polished benches, the state flag flanking an impressive judge's bench, and an atmosphere of solemn authority that immediately made my mouth go dry. I was early, but not early enough. Corinne and her attorney had already arrived and were arranging documents at the plaintiff's table. Her lawyer, a polished man in a tailored suit that probably cost more than my monthly mortgage payment, leaned over to whisper something in her ear. They both glanced in my direction and shared a small, dismissive smile. Corinne looked immaculate as always, her blonde bob perfectly styled, her navy blue suit crisp and professional. She exuded confident authority, clearly accustomed to this environment in a way I was not. I smoothed my own department store suit jacket, suddenly aware of its slightly rumpled appearance after being pressed between evidence binders in my car. "All rise." The bailiff's voice cut through my thoughts as the judge entered, a stern-looking woman with silver-streaked hair and reading glasses perched on the end of her nose. The Honorable Judge Eleanor Harmon presiding in the case of Maple Creek Homeowners Association versus Johnson. Once seated, Judge Harmon reviewed the case details briefly before addressing the courtroom. "I understand the plaintiff is represented by counsel, while the defendant is representing himself. Is that correct?" Both parties confirmed this was accurate. The judge turned toward me with an expression that seemed to blend skepticism with faint concern. "Mr. Johnson, are you certain you wish to proceed without legal representation?" "Yes, Your Honor," I replied, working to keep my voice steady. "I am prepared to represent myself in this matter." Judge Harmon nodded, though her expression suggested doubt. "Very well. Mr. Castillo, please present the HOA's case." Corinne's attorney rose smoothly, buttoning his jacket with practiced ease. "Your Honor, this case is straightforward. The defendant has accumulated 17 separate violations of clearly established HOA covenants over a period of 6 months. Despite multiple notices, warnings, and opportunities to remedy these violations, Mr. Johnson has continuously failed to bring his property into compliance." He proceeded to outline each alleged violation in excruciating detail, from my improperly colored mailbox to the supposedly oversized shed. As he spoke, he presented enlarged photographs of my property, each marked with arrows pointing to the purported infractions, many of which were barely perceptible even when magnified. "The HOA has been more than patient," he concluded, his tone dripping with condescension. But Mr. Johnson's obstinate refusal to comply with rules that every other homeowner manages to follow has left the association no choice but to seek judicial remedy. We ask the court to enforce the accumulated fines totaling $3,725 and grant authority for the HOA to remedy remaining violations at the defendant's expense. Throughout his presentation, I took careful notes, marking specific claims I could refute with evidence. Corinne sat confidently beside her attorney, occasionally nodding in solemn agreement as he described my willful noncompliance and disregard for community standards. When it was finally my turn to speak, I approached the podium feeling every eye in the courtroom on me. I took a deep breath, remembering Frank's advice to speak slowly and stick to the facts. "Your Honor, I appreciate the opportunity to address these claims," I began, my voice initially quavering but steadying as I continued. "I have prepared a three-part response. First, evidence that many of the alleged violations either do not exist or were fabricated. Second, documentation of procedural violations by the HOA board in their enforcement actions. And third, evidence of selective enforcement targeting specific homeowners, including myself." I methodically addressed each violation, presenting before and after photographs with date stamps, measurements proving compliance with size restrictions, and documentation showing that several cited regulations either did not exist in the official bylaws or had been misrepresented in violation notices. As I presented my evidence, I noticed Judge Harmon leaning forward, her initial expression of skepticism gradually shifting to interest. When I reached the matter of the shed, the largest fine at $2,500, I presented the original property inspection report, approved by the HOA prior to my purchase. "Your Honor, this document clearly shows the shed was approved during the property transfer," I explained. "Furthermore, the HOA bylaws specifically state in Section 12.3 that pre-existing structures approved under previous boards are grandfathered unless substantially modified, which this shed has not been." For the first time, Karen shifted uncomfortably in her seat. Her attorney quickly whispered something to her, but her composure had visibly cracked. My presentation continued with documentation of procedural violations, board meetings without proper notice, financial records withheld despite formal requests, and violation notices issued without required secondary approval. With each point, I referenced specific bylaw requirements and presented evidence of noncompliance by the very board tasked with enforcement. "Your Honor, if I may," I said, turning to my final evidence binder, "I would like to present data demonstrating a clear pattern of selective enforcement throughout Maple Creek." I displayed my spreadsheet tracking violations throughout the neighborhood, with properties color-coded based on frequency of citations. The pattern was unmistakable. Homes clustered near mine or belonging to residents who had questioned board decisions showed dramatically higher citation rates. "Furthermore," I continued, "I have written statements from 7 residents describing similar patterns of targeted enforcement following any disagreement with Board President Thompson." As Judge Harmon reviewed these statements, I noticed Karen whispering urgently to her attorney, her normally composed expression now tense and concerned. When I presented property records showing connections between foreclosed homes and Karen's brother-in-law's development company, her face paled visibly. "Your Honor," Karen's attorney interrupted, standing abruptly, "these allegations go far beyond the scope of today's proceeding, which is simply about covenant enforcement." Judge Harmon regarded him steadily over her reading glasses. "Mr. Castillo, the defendant is entitled to present evidence relevant to his defense, which may include patterns of enforcement. I will determine what weight to give this evidence." She turned to me. "Please continue, Mr. Johnson." As I concluded my presentation, the courtroom had fallen completely silent. What had likely been expected to be a routine judgment against a non-compliant homeowner had transformed into something far more complex. Judge Harmon studied her notes for several long moments before looking up. "I believe cross-examination is in order," she stated. "Mr. Johnson, are you prepared to question Ms. Thompson directly regarding HOA enforcement practices?" My heart raced, but I nodded confidently. "Yes, Your Honor, I am prepared." The following morning, I returned to the courthouse, my nerves somewhat steadier than the day before. The previous afternoon's cross-examination had been grueling but productive. Karen had struggled to explain the inconsistencies in enforcement, growing increasingly defensive as I methodically walked through each example of selective application of the rules. Her composure had cracked completely when confronted with evidence that her own property violated several of the same regulations she had cited against me. When asked to explain why no violations had been issued for her non-compliant garden statuary or incorrectly painted trim, she had claimed oversight, an explanation that clearly did not impress Judge Harmon. Now, as court reconvened for the verdict, the atmosphere in the courtroom felt markedly different. Karen and her attorney sat in tense silence, no longer sharing confident whispers. Judge Harmon entered, and after the customary rise and seating, she adjusted her glasses and addressed the court. Having reviewed all evidence presented in the matter of Maple Creek Homeowners Association versus Johnson, I am prepared to render my decision, she stated formally. This case presents significant concerns regarding enforcement practices, procedural adherence, and good faith application of community covenants. She methodically addressed each alleged violation, dismissing 12 outright due to either lack of evidence, procedural errors in notification, or evidence that the cited regulation did not actually exist as claimed. 3 violations were upheld, but with penalties reduced to warning status due to immediate compliance on my part. The remaining 2, including the significant shed violation, were dismissed based on prior approval documentation. Regarding the financial penalties sought by the plaintiff, Judge Harmon continued, the court finds insufficient basis for enforcement given the procedural irregularities identified. All fines are hereby vacated. Karen's expression darkened as the judge systematically dismantled the HOA's case against me. Her attorney appeared equally concerned, frantically scribbling notes as each ruling went against them. But Judge Harmon was not finished. "Now, regarding the matter of the defendant's countersuit," she stated, causing Karen's head to snap up in apparent confusion. Her attorney leaned over, whispering urgently in her ear as her eyes widened in alarm. "Your Honor," her attorney interjected, "we were not formally notified of any countersuit in this matter." Judge Harmon raised an eyebrow. "Mr. Castillo, the countersuit was properly filed with the court and served to your office last week. I have the certified receipt of delivery signed by your administrative assistant." As her attorney fumbled through his papers, looking increasingly distressed, I reached into my briefcase and retrieved my copy of the filing confirmation. Judge Harmon continued without waiting for him to locate his copy. "The court finds compelling evidence supporting Mr. Johnson's claims of harassment through selective enforcement, procedural violations in HOA governance, and potential conflicts of interest in enforcement actions," she stated firmly. "Particularly concerning is the evidence suggesting targeted enforcement against properties that subsequently sold under duress to a development company with family connections to board leadership." At this, several previously silent neighbors seated in the gallery behind me murmured in surprised recognition. Karen's face had lost all color, her customary confidence completely evaporated. "Based on the evidence presented, the court finds in favor of the defendant on all counts of the countersuit," Judge Harmon declared. "Ms. Thompson, as board president, failed to maintain proper procedural governance, selectively enforced regulations, and potentially utilized her position for personal or family financial gain, all clear violations of fiduciary duty to the homeowners association she was elected to serve. Judge Harmon removed her glasses, addressing Corinne directly. This court awards damages to Mr. Johnson in the amount of $25,000 to be paid by Ms. Thompson personally, not from HOA funds, as state statute holds board members individually liable for breaches of fiduciary duty and harassment. The gallery erupted in hushed exclamations. I sat motionless, hardly believing what I was hearing. $25,000, an amount that not only covered the stress and legal costs I had incurred, but sent a powerful message about accountability. Furthermore, the judge continued once order was restored, I am referring evidence of potential fraud and conspiracy regarding property acquisitions to the district attorney's office for review. This court will also require a full forensic audit of HOA finances and immediate board elections to be overseen by an independent party. Corinne's attorney immediately requested time to appeal, but Judge Harmon was unmoved. The judgment stands, Mr. Castillo. Your client has 30 days to render payment in full to Mr. Johnson. As the gavel fell with finality, I remained seated, my hands trembling slightly with the enormity of what had just occurred. I had entered that courtroom alone against what seemed like insurmountable opposition, and emerged not just vindicated but victorious. Around me, neighbors who had observed the proceedings approached with handshakes, tearful thanks, and expressions of newfound courage to address their own HOA grievances. Corinne rushed from the courtroom without looking back, her attorney hurrying behind her with his briefcase half closed, papers threatening to spill onto the floor. The power dynamic that had dominated our neighborhood for years had been completely upended in the space of 2 days. The emergency HOA meeting held 2 weeks after the court ruling was unlike any gathering our community had seen before. The typically half-empty room was standing room only, with homeowners who had never before participated arriving early to secure seats. Corinne was notably absent, her resignation letter read aloud by a visibly uncomfortable Tom Wilson, the only board member who had occasionally shown sympathy to homeowner concerns. In light of recent events, I find it necessary to step down from my position as board president, effective immediately, Tom read from Corinne's terse statement. No acknowledgement of wrongdoing, no apology for years of harassment, just a reluctant surrender of power. The applause that followed was spontaneous and prolonged. As it subsided, Frank, my elderly neighbor who had first warned me about Corinne, stood up with assistance from his cane. I move that we immediately vote for an interim board to serve until proper elections can be held next month, he proposed. And I further move that our first act be to create a committee to review and simplify our community guidelines. The motion carried unanimously. Within an hour, a new 5-member interim board had been elected, a diverse group including Mrs. Garcia, Mr. Patel, and, to my surprise, myself. I had not sought the position, but the community insisted that someone who had fought for fairness should help establish a new governance approach. The transformation of Maple Creek was remarkable in the months that followed. Violation notices virtually disappeared, replaced by friendly reminder letters only in cases of significant issues affecting neighboring properties. The intimidating rulebook was revised down from 87 pages to a reasonable 15, focusing on genuine community needs rather than micromanagement. Perhaps most telling was the change in atmosphere throughout the neighborhood. Gardens became more diverse and personal as residents felt free to express themselves without fear. Children's play equipment reappeared in backyards. Neighbors who had previously avoided eye contact now organized block parties and community improvement projects. As for the $25,000 judgment, Karen paid in full after her appeal was denied. I used a portion to complete various home improvements that had been delayed due to my financial strain during the HOA battle, but the majority went toward establishing a neighborhood legal fund accessible to any Maple Creek resident facing legitimate HOA disputes in the future, ensuring no homeowner would again feel powerless.